In India's democracy, elections are the bedrock of legitimacy. Yet disputes over counting often test the fairness of the system. Recently, the Supreme Court itself conducted a recount of votes in a Sarpanch election in Panipat, Haryana, the first such instance involving electronic voting machines. This rare intervention raises a fundamental question. When can courts order a recount of votes? The validity of election results can be challenged by filing an election petition. Under the Representation of the People Act, 1951, petitions for parliamentary and assembly polls go to the high courts. For panchayat and municipal elections, challenges are filed before district-level civil courts under state laws. Crucially, petitions must be filed within 45 days of declaration of results and must present material facts, not vague allegations. Courts can void elections on well-defined grounds: bribery or undue influence, such as exploiting caste or religious identities, disqualification of the winning candidate, improper rejection of nomination papers, or violation of constitutional or electoral laws that materially affect the outcome. These criteria reflect judicial restraint, protecting the sanctity of the ballot while avoiding unnecessary destabilization of governance. Recount of votes is not a matter of right. In Satyanarayan Dudani v. Uday Kumar Singh, 1993, the Supreme Court ruled that recounts require specific proof of irregularities, not speculation. In Mr. Gopalakrishnan v. Thachadi Prabhakaran, 1995, it reiterated that ballot secrecy is sacrosanct. Thus, recounts are ordered only when there is a prima facie case that mistakes in counting could decisively alter the result. While recounts are possible, declaring an election void and naming another candidate winner is rare. This requires proof that corrupt practices, like bribery, booth capturing, or ballot tampering, directly influenced the majority. Under Sections 123 to 136 of the Representation of the People Act, corrupt practices can disqualify a winner, but courts demand conclusive evidence before overturning a people's mandate. In July 2025, the Supreme Court intervened in the Buanalakhu village Sarpanch election dispute. Summoning the EVMs to its premises in New Delhi, it conducted the recount itself, an extraordinary move, as recounts usually take place locally. The court cited the peculiar facts and circumstances of the case, signaling that even grassroots elections must adhere to the highest standards of fairness. Judicial interventions in elections safeguard the credibility of India's democracy. They reassure citizens that malpractice will be scrutinized, from parliament to panchayats. Yet courts remain cautious, balancing fairness with finality, to prevent excessive litigation from paralyzing governance. The Panipat case, however, reaffirms the court's role as the ultimate sentinel of free and fair elections. Globally, recounts are contentious. In the United States, the Bush v. Gore case in 2000 changed the course of history. India, by contrast, exercises judicial restraint, demanding high thresholds of proof before recounts. This cautious yet firm approach reflects India's democratic ethos, preserving both the voice of the electorate and the stability of governance. Courts ordering a recount of votes is not about undermining elections, but about protecting their sanctity. The Panipat case stands as a reminder. In India's democracy, no vote is too small to matter, and no malpractice too minor to escape scrutiny. In this lies the judiciary's enduring role, as guardian of the people's mandate.